Should it please you, my lords, my lady. Miss Nicola Newbegin, I appear for the appellant. With me is Miss Nicola Newbegin and Miss Alana Rambaran of the Trinidad Bar. My learned friend, Mr. Robert Strang, appears for the respondent. My lords, this is an appeal that ought normally not to trouble the board, because it's an appeal that revolves around the central issue of the vexing question of costs.
Yes.
But it is, however, an appeal that is of some practical importance and immense value to the public in Trinidad and Tobago, having regard to the importance, the growing importance of the Freedom of Information Act, which the utility of which is now being appreciated and heavily used by members of the public. That, of course, is against the context, against the backdrop of the traditional reluctance of public authorities to divulge information and the healthy or unhealthy tension that exists between those who wish to dislodge information and access it. The appellant before you is a civil servant. He is a Forester 1, and he was awarded a scholarship by the government to pursue a degree to qualify himself for career advancement and promotion. Neighboring Guyana, which is in close proximity to Trinidad and Tobago, traditionally we would go there to do the degree in forestry. However, he was specifically told by the state's representatives that the degree in forestry from the University of Guyana had accreditation issues from the perspective of Trinidad and Tobago's government, and that it was no longer approved by the state to pursue that course. As a result of that, he was given a list of approved universities. He selected one from amongst those, that being the University of Idaho, and successfully read for his degree in resource recreation management and forestry. Thereafter, oh yes, my lord, I'm reminded by my junior that I did prepare a speaking note in the interest of time, which I think is before my lords.
Yes, it is.
Yes.
Thank you.
I'm grateful.
Yes.
And my lord, having successfully completed that degree, he was astonishingly told that it will not be accepted as a qualification for promotion, that being the very degree he was advised to pursue. And on the contrary, the degree he was told there were accreditation problems with, that would be instead acceptable. So you can imagine the predicament he found himself in, which is what prompted the Freedom of Information application that was eventually filed. Now, my lord, the Freedom of Information Act is used as a form of parallel discovery in Trinidad, and heavily so. It is used prior to, during the course of proceedings, and even after proceedings. And the reason for that is because oftentimes the duty to make full and frank disclosure imposed on public authorities unfortunately does not yield the kind of full and frank disclosure that one would hope for. And we have many cases where the Freedom of Information application produces evidence that was either not disclosed or is at odds with what was put into evidence, or casts a different light on matters. Now, my lords, this is important because when one gets that information, it enables them to get proper legal advice. It allows them to make a more informed assessment of the merits of their case, and also, bearing in mind the inequality in resources between the state and the citizen, it is of immense practical importance. Bearing in mind, in Trinidad and Tobago, we don't have any public funding for public law matters such as constitutional claims and judicial review claims. So the civil servant is putting out of his pocket. The Wolf reforms, which prompted the introduction of new rules of court, were ushered a new dawn in the era of litigation and the culture and approach to litigation. The emphasis was on unclogging the courts with all the backlog of matters that were causing all the delay. And to do that, one of the tools was the pre-action protocol practice direction, with heavy emphasis on mandatory compliance with the pre-action protocol that was designed to encourage parties to have no litigation by ambush, all cards face up on the table, and that will in turn provide fertile soil for genuine and meaningful dialogue that can lead to amicable resolution without lengthy litigation. Now, my lord, in Trinidad, if you do not comply with that pre-action protocol, the practice direction itself tells us that there must be consequences in costs. And it's obvious why that is so. If a public authority is not faced with any form of consequences for non-compliance, or indeed a claimant, then the whole system will fall down. Because this is actually the first hurdle in the litigation race now. What judges invariably do, my lord, and I don't know if they practice obtains here in England, but what they do is when you file for leave ex parte, because the rules require you so to do, is they invariably ask that you serve it upon the prospective respondent, and they convert it now into an inter partes hearing. It's very, ex parte granting of leave now is seldom done. You will get it in a clear case if the judge feels like that, but in FOIA cases, invariably, they will convert it into an inter partes hearing. Alternatively, as happened in this case, if by the time you reached on the doorstep of the court with your ex parte application, if by that time the information is provided, the judge will in fact consider the question of cost, unless there was compliance with the pre-action protocol by the defendant and you are in the wrong, which is not in fact the case here. Now, my lord, if it is that a public authority is allowed to flout and breach the pre-action protocol practice direction, and there are no consequences because the nature of the application is an ex parte one for leave, and by virtue of that, the civil servant, Mr. Vijay Singh, is going to be out of pocket, then something is wrong with that, my lord. It's fundamentally unfair. When the Wolf reforms came into Trinidad and Tobago, my lord, there was a bar and bench discussion that was very intense with the profession, because the work was now being front-loaded, and you had to place heavy emphasis on a proper pre-action, on the pre-action phase. And therefore, when one charges a client a fee for the pre-action, for the preparation of the pre-action letter and the pre-action correspondence phase, it is something that hitherto perhaps might not have been attracting so much attention. Now it does, and necessarily and quite properly so, my lords. Now, my lords, we have limited time, so I'd like to dive straight into the record. And I will start by taking my lords to the Freedom of Information Act itself. If I may take you to the joint bundle of, to the application at page 27 in the record of proceedings. And I'll take it up at page 27. You will see the factual context with respect to the scholarship and the issues I've already alluded to in the second paragraph on page 27. But the point is, this man was, he had a grievance. He pursued the degree that they told him would qualify him for promotion, and then they turned around and said it's not going to be accepted. You will see that at the top of page 28, and we asked for information, which you'd find at page 28, a list of the requirements for promotion to the office of ACF, copies of the merit list, the personal file, the seniority list, and all correspondence relative to his complaint about the recognition for his degree in resource, recreation, tourism, and so forth. And then, most significantly, we end that letter by saying, I hope that my client's request will be expeditiously dealt with in conformity with Section 15 of the Freedom of Information Act, that states that all public authorities shall take reasonable steps to inform the applicant of a decision on his request as soon as possible, but in any event within 30 days. That's significant. My learned friend, in his printed case, I think there's been some measure of confusion with respect as to whether this case was about the provision of the information or whether it is about this. My lords, the first thing in the structure and scheme of the FOIA is that you must have an access decision. We were at the stage where we sent the application, but we were yet to have an access decision within the contemplation of the Freedom of Information Act and as defined by it. I take you next, my lords, to the response to that letter at page 33.
So the legislation of Trinidad and Tobago allows for production of personal files concerning other employees?
It does, my lady, yes. There is a procedure you might have to go through, but it does. But
What's the procedure? Do you have to redact information?
you can redact it, and you might first have to contact them, the third parties, to see whether they have any objection.
If they have an objection, is that conclusive? Does that mean you can't have it?
No, because, I mean, if they have an objection, the public authority will have to then apply Section 35 to decide whether the objection is one that they should uphold, depending on what the circumstances are. It may very well be that the objection is to information that is not personal, like medical records. It's not personal, like your DNA or something like that. But it's just routine administrative information that pertains to your career advancement. And in that case, that is information that should be disclosed if someone is suffering a serious risk of injustice or discrimination, perhaps. But in any event, Milady, before you get there, what you're obliged to do is to write us and say, look, my access decision in respect of request 1 is as follows. In respect of request 2, and you give your access decision.
Yes, but you can't give that answer until you've actually contacted these employees.
Oh, no, my lady, but what you can do is, well, remember, bear in mind, that's just one request. You can reply to it.
Yes.
Yes, but you can reply to all of the others, and when you arrive at that one, you can say, pursuant to Section X, we have written to the affected persons to ascertain whether they have any objections, and we will revert to you. But the point is, you can't just leave the applicant in the dark.
That would be an obvious position, wouldn't it? That would be obvious.
Well, not necessarily, milady, because to a lay person who may not know the act, it may not be that obvious. And one does not know, I mean, one would not dare to presume that they are doing that. What if they aren't? Now, the response to that letter and application, milady, is to be found at page 33, my lord.
Yes.
And this is what they say. They say they acknowledge receipt of the requests dated 1st of December 2015 and January 27, 2016. I sought instructions on that 1st of December 2015 because that obviously is not the date of our letter. I'm instructed that it may have been a previous request that the applicant might have submitted on his own without the benefit of legal advice. But in any event, what is noteworthy is that the Public Service Commission, almost 3 to 4 months later, they were acknowledging receipt of the correspondence we sent them. And this is the interesting part. They say, your requests will be granted in part. Well, what part is being granted and what part is being denied? They don't condescend to say. This is not an intelligible response. And this certainly could not be what Parliament intended to be an access decision that would allow you to make a decision as to whether you can challenge it by judicial review or whether you ought to or not. Then they say, the information is being compiled, my lady. So that begs the question raised by my lady. If they're telling us the information is being compiled, does it relate to the last request, the first request? Who knows? And they say, and further communication would be forwarded to you when finalized. Now, I asked the board to note the following points. Nothing in this response complains about the volume of the information, to say, well, it's so heavy, it's so voluminous. No. There is a specific provision in the FOIA. If it is that it's voluminous, you can say so, and say that there will be a delay, and you can have deferred provision of the information. But that does not have anything to do with the access decision. You give your decision, but you can defer provision of the requested information. If your photocopier is down, you can say that. If it's voluminous, you can say that. Nothing of the sort here. They then say, so at this stage, my lord, what is interesting is they already knew at this stage what was approved and what was not approved. They clearly knew that by virtue, or else they could not have made the statement, your requests will be granted in part. And if they knew what was granted and approved and what was being denied, well, why on earth would you not simply say that? How fundamentally unfair and irrational is that? And then to say the information is being compiled and further communication will result in due course. We waited because Mr. Singh is a civil servant, the salary is very small. He waits. We wait and 73 days elapse. 73 days later, on page 35, having waited for this time, he writes a pre-action letter because he has to incur an expense for a pre-action. So he writes a pre-action because they're not getting back to him. And there's a very detailed pre-action, and you will see we complain about the request, the response to the request. At page 37, paragraph 3, we say the proposed defendant has breached section 23 of the Act. It's failed to state which documents access has been granted and refused, and it's failed to provide any sufficient reasons as to why access may have been refused. We say take notice at the bottom of the page that section 23 is breached, which requires a decision to be made and communicated as soon as practicable, but in any event not later than 30 days. We then next go to page 59. This is the response to the pre-action protocol letter. It is stunning. At page 59, they respond to a detailed and comprehensive pre-action letter to say as follows. I refer to the caption matter and acknowledge receipt of your letter, which was received in the Service Commissions Department on June 6, 2016. You will be informed once the matter has been finalized. Now, we will see what the pre-action protocol requires of a defendant who receives a pre-action letter. Again, no mention is made of the volume of the information, nothing of the sort. The application for leave was then filed, and to see that, you will go to page 5 of the record.
Can you just help me, Mr. Manager?
My Lord.
How does it take from the 23rd of May until the 6th of June for a letter to reach the department? I mean,
Well, that's a good question, and the answer is this. You will see in the affidavit.
is it posted? Is it?
No. In the affidavit, you will see we said this letter was hand-delivered.
Okay.
But what happens is when it's hand-delivered from the dispatch and mailing room to climb 2 floors to get to the relevant persons, it takes that length of time. It's the typical public service bureaucracy. And during that time is ticking away. Your clock is ticking away. But that's the answer. That's the short answer, my lord. On page 5, we file the ex parte application for leave, and the very first relief we seek is a declaration that the proposed defendant breached its statutory duty under section 15 to take reasonable steps to enable the applicant to be notified of the approval or refusal as soon as practicable, but in any case not later than 30 days after which the request is made. We then seek in the alternative, obviously, a mandamus to provide the information and the declaration that he's entitled to access. We then go, but what is significant, my lord, the primary relief sought was the access decision, because we have never received a proper access decision up to that point in time. I then take you to page 10, grounds 17 and 18. The unreasonable delay on the part of the defendant in making a decision or issuing a section 23 notice is unfair, illegal, and contrary to law. The respondent has illegally failed and or refused and or omitted to perform its statutory duties under 14, 15, and 23. I then take you to the eventual letter which we got, which is in a very thin volume, which is the supplemental record. And you will see that we received this under a cover letter dated the 20th of July. And that is because it probably has to go to the Public Service Commission before. And my lords, you will see in that letter, they say that please note that by letter dated 11th July, Mr. Singh's request for information was granted in part under the Freedom of Information Act. A letter of a copy addressed to you is appended for information. Well, we only got this letter We only got this letter after we'd filed the application for leave, and that is not in dispute. You will see in that letter, they say, I refer to your letter dated 27th January 2016, which was received on the 16th of February 2016. Well, my lords, my lady, how could it be right that you are responding on the 11th of July to an FOI request that you say you received on February 16th, when the law requires an access decision promptly and in any event within 30 days. 30 days is the outer limit. More importantly, what could have possibly taken so long when the only request that was granted is item 1? It's a 1-page that was attached to this request, and I'll take you through it. At the top of page 194, with respect to request number 1, please find attached the job spec, which is attached. It's a 1-page document. Then they say with respect to the order of merit list, there is none. With respect to the seniority list, there is none. With respect to his request to view his file, we contact someone and make arrangements for him to come in and view his file, and whatever documents he identifies on his file he wishes to have copies of, they'll make arrangements. And then my lady's point is at the third paragraph up from the bottom. In accordance with section 33, the officers Mr. Singh has referred to will be informed accordingly. They are now about to take the step that they should have taken when they got the application to inform those officers who may be affected and whose information might be considered third-party requests. With respect to request number 6, please be advised the request will not be granted because it is subject to exemption under 27. That's the deliberative process involving a public authority. Well, really, couldn't you have said that within 30 days? Where's the big, humongous volume of information to which I'll come that was referred to? Nothing of the sort. There's absolutely no evidence to support that. We then go back to the record itself, and I ask you to turn to page 60. You will see at page 60, this is the order that was made withdrawing the matter, and you will see in the 4th recital, and upon the court being informed that the defendant gave the claimant the information on the 19th of July, after the application for leave was filed on the 18th of July, permission to withdraw on costs. Well, it's not that they gave the information, it's that they gave the access decision. That's really what they gave. And one aspect of the request was granted. The High Court judgment is at page 83. And whilst we don't take issue with the judge extending the time for the application to set aside the ex parte order for costs, what we do say, my lord, is that, well, when the defendant was now before the judge, she ought properly then to have said, well, look, I made an order for costs against you ex parte, I've set it aside, but you're here now. What have you got to say for yourself about your pre-action conduct? And at page 83, we will see this is the extent of the judge's reasoning. She says in oral submission, in oral submissions, paragraph 16, the defendant relied on the Court of Appeal judgment in Absal Mohammed for the position that costs are not usually awarded at the leave stage of a judicial review application. I've reviewed that decision of the Court of Appeal. Specific guidance was given in scenarios which are not on all square fours with ours in the circumstances of this case. Nevertheless, she says, nevertheless, having said that, she says, nevertheless, in light of the fact that the defendant was not yet a party to the substantive claim and the requested information was handed over before the court made a determination as to whether leave would be granted, I'm prepared to review my order in favor of the proposed claimant, and I make no arrest of costs. My lords, my lady, one of the reasons we've brought this appeal is because there exists serious divergence of judicial opinion and confusion on the question of whether the court can make an order for costs at the leave stage. And the rationale for that is that there is a Court of Appeal judgment, several judgments, which suggest that at the leave stage, there are no parties, because parties enter the picture frame when you get permission and you file your claim. That is why in the ex parte application for leave, we refer to them as the intended claimant and prospective defendant, because they are no parties. In judicial review, there is no list between the parties, unlike private law disputes. And for that reason, in the old days, the courts took the position that you could not have an order for costs at the leave stage. Now, A, I say I don't agree with that, the correctness of that as a matter of legal principle at all. B, even if it were correct, post the Wolf reforms and the new rules of court, it cannot survive. It cannot be that for that to survive, we will be giving license to public authorities to simply do what they did in this matter and escape with impunity, because at the leave stage, they can give the information and get away. Pity the poor layman who cannot afford to send a pre-action letter or cannot afford to file an ex parte application for leave.
Well, you say you can't have, I'm sorry, I hope I wasn't...
Sorry, my lady, yes.
You say that you cannot have costs at the leave stage, but in the Mohammed case, to which the judge referred, it was clear that if leave was given, then the costs would be treated as part of the cost.
I agree, my lady.
Yes. So
Yes.
you do get them in that situation, but this is a rather odd situation where the application was being withdrawn without any agreement having been come to with the respondent.
Indeed, my lady.
And the respondent hadn't been given notice by that time, so an order could not be made.
Sure. But my lady, what I'm saying is a little deeper than that. The ramifications of that principle have manifested itself in various ways. If you have, for example, a contested application for leave inter partes, if leave is refused, for example, or if leave is refused, the court says no orders to cost at the leave stage. If there are some judges who say, well, look, if leave is granted, I'm going to make no orders to cost because we're at the leave stage. And that's why I say there is some element of confusion about it, my lady. But I'm hoping that this will be an opportunity to clarify beyond doubt, and I will take you to the judgments to show you.
But mustn't it depend on the circumstances?
Oh, yes, indeed, my lady.
Being withdrawn? Yes,
indeed. I am on the point that there is no absolute bar on the basis that there are no parties at the leave stage, ex parte or inter partes. The point is, you have an applicant and respondent.
But that's what the pre-action protocol says, isn't it?
Indeed, my lady, indeed. Now, my lady, to make good that point, if I take you briefly to page 64, you will see the ground at number 4, they rely expressly on the Afzal Mohammed case, which really is the principle that, no parties at the leave stage. And I will take you to the Court of Appeals judgment to show you. At page 88, I will show you what the ground of the appeal was, at page 88. At page 88, our first ground of appeal was that the respondent the court ought to have held that the appellant was entitled to his costs because the respondent was obliged to notify the appellant whether it was approving or refusing the request under Section 15, and that deadline had long passed. And then we go over page, then we say at Roman numeral 4, there being no response to his pre-action letter, he was forced to retain and instruct counsel to file his application for leave. And ground 5, we confront the Afzal Mohammed judgment. And I take you next to the Court of Appeal transcript of the hearing, and we commence that at page 116. Because the source, the genesis of the confusion, my lady, it lies in that very point, that at the leave stage there are no parties, and I will demonstrate that. I'll hopefully demonstrate that now. At page 116, Justice of Appeal Devines, at line 34, he says, does it make a difference that there were no proceedings commenced and that you only filed your application for leave to bring judicial review, which you then withdrew? Well, firstly, look at the way it's phrased. Does it make a difference that there are no proceedings commenced? But proceedings are commenced by virtue of the filing of the application for leave. But that is what the judge was asking. I said, well, my Lord, with respect, it doesn't. He said, could it be said that there were proceedings? I said, the answer is yes. My lord, I think the word proceedings there must be given a broad interpretation, and the mischief the rule intends to address is the failure of a public authority to respond to the pre-action letter, which has resulted in the litigant incurring expenditure. Then I take you next to page 120. This is the other judge, Justice of Appeal, Madam Justice of Appeal Pemberton, at the top of the page. Well, Mr. Ramlogan, I'm having a little difficulty, line 4. Certainly, my lady. How could a party be asked to pay costs when they have not submitted themselves to the jurisdiction of the court? Well, my lady, the answer to that is when the court was moved to, yes, but I'm not there, I'm not served, I'm not here, I'm nowhere in the building. Well, my lady, the submission is this. The court can make a cost order even against a non-party to the proceedings. The court has jurisdiction to make any order to meet the justice of the case. At large? No, not at large, but certainly if they are connected with the case, which in this case is the intended defendant. So, my lady, if we're about to say that the rules provide for the application for leave to be made ex parte, and if every time a litigant incurs the costs of moving the court ex parte as they are obliged to in accordance with the rules, if the public authority then comes and say, well, whether they got wind of it or otherwise, and gives you whatever it is you wanted, it could be a small case, it could be a big case, and they give you that, then must you go away, and the costs you incurred are simply not a matter for the court to deal with? I don't accept that. And that's the sticking point. This is two justices of appeal raising the point about we are at the leave stage. Are there parties? Have we submitted to the jurisdiction of the court? Are there proceedings? And then I take you to page 122. And you will see Justice of Appeal Smith. He distinguishes the authorities. He says, at line 27, none of them deal with a situation like ours. All of them, the parties had actually appeared and taken part. There is none of them in these cases where it was ex parte and the other party did not apply. Sure, well, I see it's very interesting. I noticed that in none of them the party didn't appear. And clearly, if the party appears, then that is a whole new ball game. And I said, well, but sure, but my lord, in this case, the party did appear. They did because they made their application, and when they made their application, they were before the court, and the court was seized of the matter. That's what I meant. And then at the bottom of the page, I said, well, you know, my lord, may I just address this frankly? My submission is simply this. The purpose and intention of the pre-action protocol practice direction is not for a defaulting, non-compliant party to escape the consequences of the breach and the violation of the protocol by relying on the technical rule that, look, I'm not before the court, but the emphasis and accent is on whether there has been compliance with the protocol. The penalty, as it were, in inverted commas, is really designed to foster and encourage compliance and to discourage non-compliance and to act as a disincentive to that.
But it's a question of discretion, isn't it?
Oh, yes, Melody. I entirely accept that it's a question of discretion. But I say on the facts, or the exceptional facts of this case, a rational exercise of that discretion in accordance with the established principles of law ought properly to have resulted in an order for costs in favor of the appellant. Now, Melody, I take you next at page 128 at the top. This is the senior counsel for the respondent Public Service Commission, line 4, at the top of page 128. He says, and he's referring to the Abzal Mohammed, and this is his submission. He says, and one of the things he said there is look here. When you're at the leave stage, there are no parties as yet. The matter has not commenced as yet, you know, and he used that as an argument in principle. That's at 128, lines 4 to 9. He repeats it on page 129, lines 10 to 11. And then at the bottom of the page, Justice of Appeal Smith says this to counsel at page 129. He says, I'm loath to cut across. I understand what you're saying, the fault of the judge for recalling the matter and the natural justice point. You made an order of a cost against me, you didn't hear me. So you fault the judge for that. Cast aside the judge for that. Now that you're before me, and now that you've come to be heard, can I not now raise the point, now that you're here with me now, and say, listen, you never complied with the pre-action protocol. And isn't the judge entitled to take that and say, I'm with you so far? Sorry, lines 11 to 12. Isn't consideration of the pre-action protocol that something should have engaged the trial judge? That's where I am. And then we go next to the judgment, the extempore judgment at page 141. Having had that discussion, but I've taken you through it, my lords, my lady, to see the role of that stage about no parties at that stage, how it loomed large in the mind of the court. Page 141. This is what the reasoning reads. At the top, line 4. We noted that in her judgment, the learned judge did not make explicit reference to the consideration of the pre-action protocol. And that may have been, we are not saying it's an oversight on her part. We have now been invited to do so and look at the circumstances to see whether failure to comply was one that should be visited with costs. In summary, we agree with counsel for the respondent. Given the circumstances, it was proper and reasonable not to respond immediately to the pre-action protocol. In fact, it was not a case that the pre-action protocol was ignored. There were attempts to comply, but the depth and breadth of the request were indeed voluminous, and efforts were made to comply. We find that it was not unreasonable in these circumstances for there to have been an order for cost and not to follow what we say in our jurisdiction is the usual order that in leave applications, especially at the ex parte stage, we make no orders to cost. So the pillars on which the decision of the Court of Appeal is based is really that they didn't find, if we dissect it and analyze it, they say this wasn't a case where they had to respond immediately. Well, I don't know why. They don't give any reason to explain why they say that. Why do you say that? Why? What was so special about this case? They don't say. They're mandated to reply within 30 days. Under the FOIA, giving an access decision, and under the pre-action protocol practice direction. It was a case, they said there were attempts to comply. They paid no heed that those were hollow, empty attempts to comply because they knew they were granting some of the requests and denying some, but they chose not to disclose it. They paid no attention to the prolonged lapse of time. And then, I don't know where this invention came into the picture about it was voluminous and efforts were made to comply. Where is the evidence of that? The Public Service Commission in its responses never even hinted at that. It simply was not an issue, and we were blindsided by this. And then they say we therefore find it was not unreasonable, and in the circumstances for there to have been an order for costs not to follow. What we say in our jurisdiction is the usual order in leave applications, especially at the ex parte stage. Now, my lord, my lady, in this matter, you would note from the application for conditional leave that the leave was granted both as of right and also to raise matters of general public importance. This matter is of general public importance because it has the potential to seriously undermine and frustrate the objectives and aims of the Freedom of Information Act, because if this stands, every public authority will do precisely what this one did. And there's a Court of Appeal judgment to guide the lower courts to say, well, nothing is wrong with that. It is, and we consider it to be, with respect, outrageous. Now, my lords, I don't think I need to take you through the actual provisions of the Freedom of Information Act, given in the interest of time. But what I will do, my lord, is take you to the pre-action protocol practice direction briefly, which you'll find.
Section 15 requires the public authority to take reasonable steps.
Yes.
It's not an absolute obligation.
Would you like me to take you to the act, my lady?
No, I've read it.
Okay, you've got it, fine. Right, so can I take you to the joint bundle of authorities quickly? And
actually, I just wondered about that. I read it twice.
oh, sorry, my lord. What's this about?
But Section 15.
Yes.
A public authority shall take it's on MS 673. A public authority shall take reasonable steps to enable an applicant to be notified of the approval or refusal of his request as soon as practicable,
Yes.
but in any case, not later than 30 days after the day on which the request is duly made.
Yes, my lord.
Now, I think her ladyship, as I understood her, was suggesting that the obligation is always one to take reasonable steps. An alternative reading might be that it's you have to take reasonable steps to notify the applicant as soon as practicable, but in any case, you must do so not later than 30 days after you receive a request.
That's correct, my lord. My lord, the way we have interpreted it in our jurisdiction, and there is a large body of jurisprudence on FOIA law, is that this mirrors the provision for judicial review, that you must come promptly, but in any event not outside of 3 months.
Right.
And it's along those lines. 3 months is
Well,
the 1 month is the outermost limit.
Yeah.
I mean, I've heard what's fallen from my lord, and I do raise the point very respectfully, but it doesn't say in the penultimate line, but shall give notice to the applicant in any case not later than 30 days. So I had read it as that tailpiece as qualifying the as soon as practicable, so that throughout there is an obligation to take reasonable steps. The obligation is to do so as soon as practical, but that is circumscribed by the following words, not later than 30 days. But it's always one to take reasonable steps.
Well, yes, my lady. But even so, we will say in this case, there's no evidence of any
Oh,
reason.
no, I appreciate the argument.
Yeah, but
Sorry.
I'm with you.
But just as on the interpretation, I had read it differently. I need to think about it in the light of my Lord's observation.
I wonder if there's a third possible interpretation, which is that reasonable steps is about the nature of what you have to do, but as soon as practicable, but not in any case later than 30 days, cover the whole ground so far as the time in which you have to do it is concerned.
Yes. Perhaps I can take you to it might help us.
Can I just ask Mr. Ramrogan, are you aware of any decision either of the board or of the Court of Appeal deciding which of these interpretations is the correct one?
I am, and I'll come to it, and I'm looking at the clock. My lord, can I just ask you to note that in section 23 on page 679, you will see that a public authority is allowed to make a decision that you're not entitled to access the document, or that the provision of access to the document be deferred. So that this is the provision public authorities use if they grant the access decision, but the provision of the actual information can be deferred. Can I just go straight to the case law in that event, and I skip the pre-action protocol practice direction?
Well, that I thought is perhaps your strongest point.
Well, my lord, it is, but I mean, my lord asked me to take him to the case law, and I'm looking at the clock because the board did curtail the speaking times, and I want to respect that. My lord, can we go to page 650? At 650, you will see the first rule. 4.5, compliance with practice directions. This is in our rules of court. 4.5, a party must comply with the relevant practice directions unless there are good reasons for not doing so. And if a party fails to do so, the court may make an order for costs against them. I take you to page 712. And at page 712, you will see 2.1, the court may treat the standards set out in our protocols as normal, reasonable approach to pre-action conduct. The court will expect all parties to have complied in substance with the terms of an approved protocol. If the proceedings are issued, the court may take into account the failure of any party to comply with a pre-action protocol when deciding whether or not to make an order for costs under Part 26. 2.4 on the next page, if in the opinion of the court non-compliance has led to the commencement of the proceedings which might otherwise not have needed to be commenced, or has led to costs being incurred in the proceedings that might otherwise not have been incurred, the orders the court may make include an order that the party at fault pay the costs of the proceedings or part of the costs or of the other party. 2.5, the court will exercise its powers under paragraph 2.4 with the object of placing the innocent party in no worse a position than he would have been in if the protocol had been complied with. I then take you to page 718, and I ask you to note that there is a specific protocol for administrative orders, i.e. judicial reviews. And this is the specific one that is addressed to public authorities. Letter in response at page 718 at the bottom. Defendants should normally respond within 30 days using the standard format at Annex B. Failure to do so will be taken into account by the court in exercising its discretion under Part 26. Where it is not possible to reply within the proposed time limit, the defendant should send an interim reply and propose a reasonable extension. Where an extension is sought, reasons should be given, and where required, additional information requested. This will not affect the time limit for making a claim for judicial review, nor will it bind the claimant as to where he considers this unreasonable. However, the court considers that a subsequent claim made prematurely, it may impose sanctions. If the claim is conceded in full, the reply should state so in clear and unambiguous terms. 3.4, if the claim is being conceded in part, or not being conceded at all, the reply should state so in clear and unambiguous terms. And at B, provide a more detailed explanation for the decision if considered appropriate to do so. I take you next to page 653. And you will see at page 653, you will see that at part 66.65, in particular, it decided who may be liable to pay costs at the top of the page. The court must have regard to all the circumstances. In particular, it must have regard to A, the conduct of the parties, and subsection 6 below. The conduct of the parties includes conduct before as well as during the proceedings, and in particular, the extent to which the parties complied with any relevant pre-action protocol. That's it for the pre-action protocol. Can I take you to the authorities at page 343? At page 342, 343, you will see we have the importance of the Act. The object of the Act is to make freely, 342. Yeah. The object of the Act is to make information freely accessible to the public with a view to promoting transparency and accountability in decision-making. It's an important piece of legislation in a post-colonial society in which bureaucrats have historically been reluctant to expose their decisions to the glare of public scrutiny. Freedom of information is also important in a society that is politically polarized along ethnic lines and in which appointment to public office, which this case concerned, and decisions involving the allocation of state resources are often subject to speculation and mistrust. Against this historic and social background, the right of access to information for public authorities must be jealously guarded and must not be allowed to be whittled down. Information requested must be provided unless refusal is permitted by the Act, and public authorities must provide adequate and intelligible reasons for refusal. I take you to page 394, which is another Court of Appeal decision, given the lead judgment is Justice of Appeal Jamada at paragraph 8 on page 394. There is no dispute that the policy, purpose, and object of the Act is to create the general access to information in the possession of public authorities, limited by exceptions and exemptions necessary for the protection of essential public interests and private affairs of persons. There can no dispute that the court is mandated to interpret the Act purposively so as to further the policy, purpose, and object above. In this context, the general mandate, section 15 provides, we've read that, paragraph 10, the FOI sets 30 days as the outer limit for a response by a public authority to a request for information. Explanations were given for the delay for the request in this case and so forth. But, my Lord, that's how we've interpreted it. I then take you to page 608. And at page 608, another Court of Appeal judgment, at paragraph 11, there is a statutory onus on a public authority which is refusing access to information to strictly comply with the requirements of Section 15 and Section 23. In this regard, the mandatory obligation denoted by the use of the word shall in 23(1) is significant. The statute creates a positive obligation to state reasons for a decision to deny access and to do so within 30 days after the day on which the request is made. Again, page 608, my lady, letter A. But the second confirmation by the Court of Appeal differently constituted that we interpret Section 15 as meaning that you have 30 days to get it, to provide the access decision. At the bottom of the page, to permit a public authority to provide new reasons as and when they see fit or as of right, and without any form of explanation, such permissiveness may not only be unfair, but could serve to undermine the intentions and purposes of the specific provisions of the FOI and the statutory regime. That's why I mentioned the absence of anything about voluminous documents. Nowhere was that given as a reason by the respondent. That emerged for the first time in the reasoning of the Court of Appeal, and it's wrong. Now, my lords, my lady, time does not permit me to go through the English cases. We've set out the passages in the case for the appellant. But there is one case from Trinidad that I'd like to refer the board to. But I will, of course, ask the board to look at what was said in the family planning case and the well-known, is it Barter? Barter case, which are both English authorities. Barter, I ask you to look at page 499 to 502. I'll give you the references. In Barter, I ask you to look at 499 to 502. In the family planning case, I ask you to look at page 600 and 603. The authority to which I ask you to have regard, my lady, my lord, it was passed up and it should be on the side. It's a recent judgment. And this judgment shows you how serious we take compliance with pre-action. My lady, if a claimant does not comply with that pre-action protocol, judges, they move faster than Usain Bolt to visit the claimant with costs to pay the public authority. And I don't understand why there is this corresponding reluctance when the shoe's on the other foot. In this case of Bisnath Mirage, this was a leave application. And the judge, as I pointed out, all of the judges now, they would direct the other side be present. I take you to paragraph 28.
I'm so sorry, page?
No, this is a loose leaf judgment, my lady. It's on the side. Does my lord have it? It was passed up this morning.
Did you say 28?
Sorry?
Did you say paragraph 28?
Yes, please.
Yes.
Thank you.
And this is what paragraph 28 says. This was a case where the information was available in legislation. So the information, you didn't have to request it, really. Paragraph 28. However, on the question of costs, the court is entitled to consider the conduct of the respondent in the face of the FOI request. The combined effect of sections 14, 15, and 23 places a duty on the respondent within 30 days from the receipt of the FOI request to inform the applicant that the information requested was in legislation, and which was a matter of public record, and which the respondent had no duty under the FOI to provide. This was not done by the respondent. Instead, the respondent replied to the applicant on 3 occasions, but still did not see it fit to inform the applicant that the information he was asking for was in legislation. The respondent's pre-action conduct precipitated the filing of the application. Indeed, if the application was not filed, it is reasonable to conclude that the respondent's position would have remained unknown. In my opinion, the approach taken by the respondent is not consistent with his duty under the FOI. In the circumstances, it was the failure by the respondent to comply with his duty under the FOI that resulted in the filing of this application. The duty was to provide the response indicating the source of the information and to indicate they had no duty to provide the legislation. The respondent failed to do so, and for this reason, although I would dismiss the application, I would order the respondent to pay the costs of the application. Since if the respondent had responded appropriately to the FOI request, In my view, this application would not have been necessary. Order. Application filed on 11 July for leave is dismissed, respondent to pay applicant's cost. So that even though the application for leave was dismissed and the non-compliance with the pre-action protocol practice direction was of such immense importance, the judge visited the defendant with costs. And that, quite frankly, I submit humbly, most respectfully, is the correct approach, lest public authorities escape with impunity. One has only to consider what the ramifications would be if a man is not able to retain a lawyer to file an application for leave. Then he will be left hanging in the lurch with a pre-action letter, a vague, ambiguous response. He can't afford to retain a lawyer to carry it further, and then what? The public authority just doesn't provide the information, and the FY is frustrated. So, my lord, it's a serious issue with a lot of practical consequences, and I humbly submit that the appeal should be allowed in this matter. I'm obliged, my lord. I think I went over by 1 minute. I'm grateful.
Thank you very much, Mr. Ramlogan. Yes, Mr. Strang.
My lords, my lady. I'll start with just the question of the point of law of general public importance. My learned friend said that leave was sought on two bases, as of right and general public importance, and has submitted that leave was granted on both bases. I don't think it's necessarily correct to infer that from the fact that leave was granted. Leave was granted, in my submission, because it was never going to be in doubt, because the Judicial Review Act, Section 23, provides for leave as of right from any decision in judicial review proceedings. And there's no threshold amount or value, there's no other threshold criteria. So leave was never in doubt. There was no express decision by the Court of Appeal below that there is a point of law of general public importance. My Lord Briggs will no doubt recall sitting in the National Gas Company appeal about the automatic strikeout. In that case, the Court of Appeal carefully identified what the point of law of general public importance was when we granted leave. There's no such express decision or identification of the general point of public importance by the Court of Appeal in this case. The point of law as it was put at leave by my learned friend is at page 156. That's the second bullet point. So that was the point of public importance that my learned friend identified when seeking leave from the Court of Appeal. It's put somewhat differently today before the board. Now the point of law of public importance is said to be a divergence of judicial opinion about costs at the leave stage and whether proceedings can be said to have started. A very different point of law of public importance, I'd say. So, my lords, I would ask you to be careful before deciding that the Court of Appeal below has already decided there's a point of law of public importance in this case. I don't say that can be correct. It's a matter for the board whether there is an important point of principle that would set aside concurrent decisions in respect of an exercise of discretion on costs. Because that's the starting point. This is a decision on costs, an exercise of discretion made by the judge on the particular facts of the case before her.
I just want to be quite clear about that, because some of the observations made during the course of the hearing before the Court of Appeal seem to be suggesting that the court had no jurisdiction to make an order as to costs because inter partes proceedings were not yet underway.
Yes. Well, once you see how the oral arguments progress, you'll see that was not the final position of the Court of Appeal. Let's start with the policy points, or whether the court was fettered by some mistaken idea about a policy or a lack of jurisdiction. And first of all, my submission about the judgments at page 141 is that the Court of Appeal is not there describing a policy which binds it. So this is page 141, line 17.
It's not made easier to understand by the fact that
No,
I think if this had been revised, this transcript, it would probably have said, we find that it was...
there certainly appears to be a negative missing, or,
yes, exactly.
or a negative too many.
Yeah.
But making allowances for that...
Yes, reasonable for there to be no order for costs and to follow the usual order.
Indeed, that's certainly the effect of the decision. But in my submission, what is being described there is a practice that one may, from which one can depart. That's the first point. And in answer to...
That being apparently hung on the main peg of a conclusion that the lack of an immediate response to the pre-action protocol letter was a proper and reasonable response.
Yes, my lord. So the first point is that the policy nor the practice, they're not the things that disposed of the appeal. What disposed of the appeal, as far as the Court of Appeal was concerned, was their finding that the respondent had behaved reasonably, at line 10. But in answer to my Lord Reid's question about this, whether the Court of Appeal remained in a state of confusion about whether there was a jurisdiction at this stage, that's clearly answered at the end of oral argument, beginning of page 137. You'll see at line 16, my learned friend addresses that point, asks the court whether this is a sticking point. Justice of Appeal Smith says, we haven't said anything yet. I know, my lord, I just want to get it clear. But Justice of Appeal Smith, I see it as a question of discretion. And that's repeated over the page 139. Down at the bottom of the page, line 44. And here he says he's speaking for the whole of the court. Line 44, page 139. We accept we have jurisdiction. And it is always a question of discretion.
Yes. Yes, and Justice of Appeal Devine says the same just below the letter at line 14. Referring to the 30 days and says that the court has discretion to decide whether to order costs. Yeah.
And Justice of Appeal Devine says it at the top of page 138 as well, my lord. Yeah. Line 1, line 2.
Yes, that's very clear.
So my lords, the Court of Appeal was not labouring under some misapprehension about whether these were proceedings and whether it had jurisdiction. Yeah. And it wasn't fettering itself by a policy. As for the practice that's being described, I say it should be understood as referring only to ex parte hearings. Justice of Appeal Smith, in his extempore judgment, says, this is a line, we're back to page 141, the usual order that in leave applications, especially at the ex parte stage, we make no order as to costs. Well, that leaves it open whether he's talking about both stages and just especially at the ex parte stage. But in oral argument, it's plain that he's making a distinction between hearings without notice and hearings where the respondent appeared. And my learned friend actually took you to that. That's page 122. Line 26.
Yeah. And they referred in connection with the practice to the Afzal Mohammed case, but so far as I can see, I'm not sure that that really covers our situation. Because
Well, I agree, my lord. I don't say it does cover our situation.
No, I mean it deals firstly with cases where after the leave stage there are substantive proceedings inter partes, and there the usual order seems to be that the costs are reserved to the hearing of the substantive application. Yeah. Alternatively, if the court brings the proposed defendant into the proceedings at the leave stage, then in order to assist it, there's then some discussion of how that should be dealt with in costs. Yeah.
Right, my lord, to say that our situation is a particular one. It's outside the ordinary, I say, the particular circumstance being that the judge's second decision is made in the context of her first erroneous one. The second hearing, inter partes, resulted from the fact that at that first hearing, the appellant had unfairly sought a costs order without notice to the respondent. And the judge had, in error, made the order. So the respondent was then presented with an order for costs against it that had been made without its knowledge. It didn't know of the hearing or the appellant's reasons for seeking it. It's no surprise that the respondent would apply in those circumstances to set it aside.
Yeah. And under the procedure in Trinidad and Tobago, the claimant could have served the application for an order for costs on the respondent, who could then have taken part in the hearing. Yeah.
CPR provides at leave stage it provides for alternatives of going ex parte or inter partes. But certainly by the time the respondent makes its application to set aside, if the appellant was going to put the respondent to the test on its compliance with the pre-action protocol, it had an opportunity after the respondent made its application to put in some evidence or put in a response and say, well, no, it's not just about the fact that you were absent and this is not an Afzal Mohammed case. You need to explain to the court why you failed to comply with the pre-action protocol. Yeah. That wasn't done.
As I read the extempore reasoning, it's really exercising a discretion afresh, really on the basis that although they don't find it in terms, there was a sufficient worry that the judges not mentioning the PAP meant that the task ought to be undertaken again.
They did the appellant the service of considering that, but the Court of Appeal made the point that they weren't finding that the judge was in error or she'd made an oversight. I'm not sure whether they had this in mind, but it's worth remembering that the judge was not asked to deal with any particular arguments on the pre-action protocol. So that's a reason why I say this is really no basis for an appeal to the board, because the protocol wasn't argued before the judge. Before the judge, she records what arguments were made to her, and that's page 81, paragraph 7. So you'll recall, my lords, that the appellant didn't put in any response or any case that the respondent had to meet about costs, but we see what was argued before the judge, paragraph 7. I take that to be effectively the submission, well, I effectively won the case because I got the information in the end. That was the submission made to the judge. nothing about the pre-action protocol. And that's why I say that isn't a sound basis for a second appeal to the board, bearing in mind the statements of principle about appeals on costs that I set out in my written case. And I may not need to take your lordships to them, but Lord Carswell in Fury and LaRue, this is page 447, paragraph 49. Well, I'm really looking at the last part of paragraph 49 at the top of page 447. The cost is peculiar in area in which the principles should be developed and applied by the judges at first instance with the oversight of the Court of Appeal. Sorry, my lady.
Yes, I,
Page 447.
that's the passage you cited.
Yes, it's the same one I cited earlier in my case, but it's, yes, principles should be developed by and applied by judges at first instance with the oversight of the Court of Appeal. The House should not reverse a cost order without a strong reasoning principle. That approach would suggest that arguments on costs not addressed to the judge at all are not a sound basis for a second appeal to the board. The other element of the protocol question is whether the Court of Appeal itself properly took into account the respondent's failure to comply. And I say that it did. It did carefully consider the question of the protocol. Those were the arguments that were put to it by the appellant. That was the focus of the appellant's appeal. And my learned friend showed you at page 130, where Justice of Appeal Smith then put that argument to the respondent. Line 2 to 12. So the Court of Appeal got the point, understood it perfectly clearly, put it to the respondent. And it didn't then go on to make any erroneous statement of law about the application of the protocol. It disposed with the appeal by making a finding that the respondent had behaved reasonably. That the failure to comply with the pre-action protocol was reasonable, I suppose I should say.
It's rather, it might be thought to be, rather a surprising conclusion that a failure to respond to the pre-action protocol is reasonable.
Well, it's a finding that was within the Court of Appeal's ability to make that finding. I say.
Yeah.
Oh, it's a sort of evaluative finding, I suppose.
It's an evaluative finding, yes.
It's difficult. I'm in slight difficulty understanding whether they're saying it wasn't a failure to comply because they responded in a proper and reasonable way, or it was a failure to comply, but a sort of mitigated by aspects of propriety and reasonableness, or mitigated by aspects of the volume of the request.
Yes, well, I wouldn't say that, I wouldn't submit that the respondent complied with the pre-action protocol in everything it was required to do. But the Court of Appeal put this to the respondent, and Mr. Martineau, for the respondent, set out the respondent's case on it at some length over page 130 to 131 and onwards. And the Court of Appeal made a finding that the respondent had conducted itself reasonably in not responding. And they refer to, as my learned friend has pointed out, the broad request and the fact that efforts were made to comply. My learned friend criticises the basis for that finding, whether there's any evidence at all for it. Well, the evidence I accept is thin, but remember the context in which this case was not put to the respondent before the judge. It was not told to come to the judge and explain itself in evidence, explain its efforts to comply. What we do know is what the request asked for. That's page 28. And that's what Mr. Martineau took the Court of Appeal to and showed them the request. And it is a broad request. And it's said that, it couldn't have been a very broad search because the respondent only granted 2 requests. But if we take a look at the largest request, the 6th one, all correspondence between effectively 4 departments and or any other state agent, entity or person relative to the question in respect of the recognising of his degree. So in order to, now in the end the answer was this correspondence is exempt for the reason that it concerns policy discussions within departments. But in order to decide that, you're still going to need to find and go through correspondence between 4 different departments and any other person who might have been concerned with the decision. So,
well, I understand that, but if that was the position in relation to the correspondence when the PAP letter was received, why don't the rules about what you're meant to put in a response to a pre-action protocol require you to explain that as your difficulty and why it's taking you further time?
Well, I accept that the respondent's reply was far from perfect,
well,
yes. But the Court of Appeal has found it to be reasonable in the circumstances, and the question is whether there was any basis for the Court of Appeal saying that this request was a broad one, and there certainly is there. And the second finding of the Court of Appeal was that the efforts were made to comply. Well, that's what Mr. Martineau repeatedly said to the Court of Appeal in submissions. In terms of the evidence, there is the fact that the respondent replied to say it was complying and it was compiling the information. And there's the fact that it did eventually comply with a response. So there is grounds for making the finding that efforts were made to comply. That's made in the circumstances, as I say, where it wasn't put to the respondent in the first instance. The other issue that led to some confusion in the Court of Appeal was that submissions effectively covered both the Freedom of Information Act and the pre-action protocol. So you'll see page 111. This is where my learned friend sets out for the Court of Appeal the failures in the respondent's initial response to the Freedom of Information Act request. You see line 23. Your request will be granted in part. The information is being compiled. Further communication forward. That's the Freedom of Information Act response being read out there. But the submission is that's a breach of the pre-action protocol in this direction, for 2 reasons.
I wonder if that's a slip of the tongue.
Yes,
Because at that
undoubtedly.
stage, the pre-action protocol letter hadn't even been written.
That's right, yes. It is a slip of the tongue, but the same slip of the tongue is made at line 46 on the same page. And that, in my submission, probably explains why when the Court of Appeal deals at the end, at page 141, with requests, with the failure to comply with the protocol, they conflate it with the response to the Freedom of Information Act. It's line 13, page 141.
I think I may share their confusion. The letter being quoted is the one we have at electronic page 59, I think.
That is the pre-action response.
That is the pre-action.
That's the shorter response.
Yes. Right.
111 is quoting the letter at page 33.
Oh, yes.
Yeah.
Yes, which, if anything,
Further
is
information.
more informative. Yeah.
My Lord, I've dealt with the question of policy and the question of the protocol. Just on the question, one of the other arguments that's made is that the Court of Appeal should have acknowledged that the appellant is the winning party. Well, again, I say that's not a good reason in principle to overturn costs decisions on appeal to the board, because that argument wasn't made to the Court of Appeal. The argument in the Court of Appeal focused on the respondent's failure to comply with the protocol.
Difficult argument, isn't it? Because the response was given in ignorance of the proceedings, which shows that it wasn't the proceedings which were the cause of getting the information.
Well, indeed, my Lord. That's one of the difficulties in the decision before the judge, which I say gives her a wide discretion. And in fact, the response was sent on the 11th of July, a week before the issue of proceedings. We don't have the initial response letter in the bundle. We have the second response letter.
And it's a point that rather cuts both ways, because the response to the pre-action protocol, the letter sent in response to the pre-action protocol letter, was dated the 9th of June, so it was only 2 days before the final response.
July. The final response
Oh,
was
beg your
11th
pardon,
of
July. Yes, you're quite right. It's a month and 2 days. I beg your pardon.
Yes, so my lady's point is one that I take. It's not obvious that the appellant was the winner, because not only had the respondent not denied the appellant's requests, but told him it was compliant with the information, then sent the information on the 11th of July, which was a week before the issue of proceedings. And we don't have that letter.
No.
We have the second letter that was sent. That's in the supplemental record at page 192. So, and this is a letter of the 20th of July saying, this appears to be, we appear to have a reply to the pre-action letter and a previous reply to the request under the Act. And this one is sent on the 20th of July, and you can see it was received on the 22nd. So post can take 2 days And it encloses the letter that had already been sent on the 11th of July over the page. And this is the copy that was enclosed with the second letter. We don't have the first one that was sent, but the appellant informed the judge that that was received on the 19th of July. So it took 8 days to get there. And it's not obvious how a judge should deal with that when it comes to the costs of proceedings. And I say the judge had a wide discretion on that.
It is important that the proceedings were withdrawn in the light of this response. There wasn't any further request saying,
That's right.
sorry, that's wrong.
That's right. That's right. May I just check that there's nothing else I wanted to say? With regard to the Court of Appeal's failure to take into account failure to comply with the Freedom of Information Act, well, I say actually the Court of Appeal did, as I've demonstrated. It was dealing with both failures when it found reasonably.
Are you going to say anything about Section 15?
Section 15 about the meaning of it. Well, I don't argue against the Court of Appeal decisions below, and I don't say it comes up as an issue in this costs decision. I don't dispute that the Freedom of Information Act imposes important duties on public authorities. But to deny costs in the particular circumstances of this case is not to deny the importance of the Act. On the question of success, I said that it wasn't obvious that the appellant was the winner of proceedings. It was put to the judge that that was the decisive consideration. And she recorded that it was put to her, so we can take it that she took it into account. And her decision was page 83, 17. Paragraph 17. In light of the fact the defendant wasn't a party in a substantive claim, and the requested information was handed over to the proposed claimant before the court made a determination as to whether leave would be granted, I prefer to review my order for costs. In my submission, that is a fair exercise of her discretion on the facts and the arguments before her. And it needs to be read as taking into account that there may yet have remained a doubt over whether such circumstances, and therefore a doubt over whether the information before proceedings and before the respondent had notice of them, and no further relief being sought. And it was also in evidence before the judge that the appellant had already been given some of the information he sought by another route. Because he made freedom of information requests to a number of different public bodies in respect of this matter, including to the Ministry of Agriculture, Land and Fishery, and he wrote a pre-action protocol letter to that ministry, which was part of the material before the judge, and that's at page 48.
When did he obtain that?
The pre-action protocol letter is dated the 1st of June 2016. It complains about the ministry's response on the 10th of May, when the ministry provided the documents listed in the middle of page 49. So as it turned out, the appellant had already received 3 other parts of what he sought from another ministry, and it doesn't appear that he needed what he sought from this respondent in order to start his main proceedings, the ones on which he was ultimately successful, for a constitutional claim, because he issued those on the 8th of July 2016 against the Ministry and the Public Service Commission. So 10 days before issuing his application for leave in respect of this ancillary, if you like, relief in respect of the information. That doesn't appear in the Statement of Facts and Issues, but it does appear in the timetable of the first instance decision in the appellant's main claim, which I handed up to the board. It's over there on the side.
So that's a confirmatory of the fact that not all the information that he sought was obtained by the proceedings.
Well, it's I wish that timetable to be before. It's page 10 of 25. That's the first instance decision in Mr. Singh's main constitutional claim. And that there may be the Court of Appeal decision too, but I'm looking at the first instance one, which is, it should be a 25-page document, is that right? And page 10 sets out part of the chronology. In the main proceedings, Mr. Singh sent pre-action letters in January of 2016 and issued his application for leave in July 2016. I wish that table to be before the board because I didn't want there to be an impression that Mr. Singh needed the information in these proceedings in order to bring his claim.
And there we see that the Public Services Commission had responded in March.
To the substantive claim. Yes.
Was this before the Court of Appeal or the judge?
No, it wasn't. It occurred to me that I ought to find it when I saw that the appellant's case referred to his success in his main claim. I just wanted to be sure that the timetable was all available. But no, it wasn't before the judge or the Court of Appeal. I don't have any further submissions to make unless you have any questions.
Thank you very much, Mr. Strang. Mr. Logan.
My Lord, can I deal with the factual issue first, my Lord? You would note that in the courts below, no issue was taken with respect to when the letter was received. That is the access decision letter. This is the first time it's been raised. In fact, the ground on which the application was made to set aside the ex parte order was, as I showed you before, was the Afzal Mohammed judgment. Nowhere in the affidavit which was filed by the respondent in support of its application, which you would find at page 68, nowhere in that affidavit, bearing in mind that they would have received the order and the order would have recited the fact that we had said to the judge, we received this after we filed the application for leave. So they would have known of that fact. And nowhere in this affidavit did they condescend to dispute that. Did they condescend to give an explanation as to for the breach of the pre-action protocol? Nothing. The affidavit is bare in its terms and says precious little except at paragraph 9. If they were present at page 70, if they were present, it is likely that there would have been no orders to cost given the guidelines in Afzal Mohammed. So I must confess, my lords and lady, to be taken aback by the position for the respondent that there is some dispute as to when the letter was received.
May I say that there's not, the statement of facts and issues in the précis put the common position that it was received on the 19th.
Yeah.
I'm not disputing that, I'm just...
Yeah.
Oh, I'm obliged. Well, if that is not in dispute, my lord, then the further query, I think my Lord Briggs had raised the issue of the timing. My lord, sometimes the commission would send documents with a driver. Sometimes they may send documents by mail. Sometimes they send it with a clerk. But the point is, they are the ones who will know the mode of delivery. We won't. All we will know is when we receive those documents. So that might account, my lord, for the 8 days versus the 2 days, as the case may be. But that's a matter for them to put evidence to meet. So I hope that takes care of...
And for what you said earlier, it rather sounds as though the practice isn't to stamp a letter with a date the minute it's received in an office building, but for the date of receipt that we see in letters to be the date when it actually found its way onto somebody's desk.
Sure.
Elsewhere in the building.
Sure.
Yeah.
That's the Public Service Commissions. That's how it works. I mean, oftentimes we get letters and the stamp. I mean, from the time it leaves the commission to get to the mailing room, to get to the dispatch clerk, to actually reach the post box, the delay is phenomenal sometimes. Yeah. Now, my lord made the point that we could have served the application for costs on the other side. My lord. That's unfortunately it's a good, obviously a good practice, but it's not something that we have in our rules, as it were. No. When the application for leave ex parte came up before the judge, she made the order. We don't have any transcript of that hearing before the judge, and when I would ask that we take what the judge says in the judgment. She refers to section 15 in her judgment, and. It's not a question of the winner or loser and not making the point about the breach of the pre-action protocol at all, because Section 15 clearly featured in what she recorded us as having argued, and Section 15 deals with the timeline. Now, my lord, so I don't accept that it would not have been put to the judge that there was a breach of the pre-action protocol procedure. The breadth of the request, my learned friend, does a good job of making heavy weather of that, but with respect, that's one request, but more significantly, can I take you to page 23 of the record? Because what we were asking for is documents in the possession of the Public Service Commission. It's not that we were asking for documents from any other department, it's documents that you have in your possession. But more significantly, at page 23, in paragraph 10, the appellant says, he completed his degree in August of 2009, and it was only by letter dated August 4th, 2014, from the permanent secretary in the Ministry of the Environment that he was told that only officers with a Bachelor of Science degree in forestry would be offered an acting appointment. So when we look at the request that was sent, if I ask you to look at page 36, you will see the request on page 36, the bulky one that seems to be providing evidential basis for this finding. We asked for all correspondence between Service Commission and the Ministry or Ombudsman or CPO and any other state entity relative to Vijay Singh's complaint about the recognition of his degree for the purpose of acting appointment. That is a 2-year period, 2014 to 2016. How much correspondence could there have been? And in any event, it's not that they have to go to all the other departments. We are asking for documents that were in your possession. So it stretches it a bit to say, well, to create this idea that there was so much work to be done. They well knew what we were asking for. The point about the winner versus loser, we say even if that is the analysis, we won because what we wanted was an access decision. What we were entitled to was an access decision. We were not yet at the stage with respect to the provision of the information. That's why I painstakingly referred to how we framed our case in the pre-action protocol, in the grounds, and in the notice of appeal. What we were asking for is, look, what we were entitled to is an access decision within 30 days.
Yes, but you agree to withdraw the proceedings. If there had been some contest that the documents provided were not enough, you would have been able to pursue the proceedings that you had started.
No, Melody, with respect, what you would do is, because you've gotten the access decision, you've got to study those documents, and you may file a claim for fresh judicial review if you so desire to challenge the exemption, because that's a fresh claim. That's the way we approach it. You don't, the first one, you've got your access decision, that has come to an end.
You didn't have to do that, is my point, because your complaint is that there hadn't been compliance with the Act, and if they fail to respond with the appropriate documents, then, and that was the position at the date of the issue of the...
That's correct, Melody, yes.
Then you can say you still haven't complied with the Act. Try again.
Well, you mean in terms of after we got the information, the response? Yeah, well, Melody, that can happen. You can file a fresh claim, or you can, I suppose...
Pursue the proceedings you've already got on foot.
Well, no, Melody, with respect, what the court says that, that's come to an end, and they prefer that you file a fresh claim to challenge the exemption, because that's a differently pleaded case. You will have to amend your claim substantially, because you will now be shifting the basis of your claim from your right to an access decision within 30 days to an entirely different case where you're challenging the exemptions, and you've got to set out your grounds. It's a totally different case.
Well, so be it, but the position on the date of the issue of the judicial review proceedings is what matters. Certainly. And it's an agreed fact that you hadn't had a response which complied with the Act.
That is correct.
Date. So you can still say what you got after that date did not comply. But did your client ever pursue any of the documents which you were refused access to in the letter of the 11th of July?
But Melody, bear in mind that all of this information we were guarding was fed into the nodes of the substantive claim. Yes, and we did, in fact, in the substantive claim, there were substantial case management conferences. Disclosure was ordered by the judge so that we got all of the information. That's how remember this case, we eventually won it in the Court of Appeal.
But did you have to go back under the Freedom of Information Act?
No, we did not, Melody, because in the substantive proceedings, this information was disclosed to the court by way of affidavit evidence, and the other FY requests as well, and whatever was missing at case management, the judge did in fact speak to the counsel who appeared for the defendant, and they produced whatever information was necessary to do justice to the case that might have been missing. So there was no need to, my lady. There was no need to, because in the substantive claim, we were able to get the relevant information to deal with the issue.
But the judge couldn't adjudicate on a claim that there was no obligation to disclose under FOIA. All he could do is, if that was the position.
Oh, no, my lady, but remember the judge has the normal powers of discovery available to him in that trial. You see? So he can, in utilizing his powers under the rules of court, not the FYA, it's a different route to reach the same destination. So that given the scope and breadth of the case management powers and the wide scope for disclosure orders, that's how the judge would approach it.
Thank you.
I'm obliged, my lady. Now, my lady, the other point, we do ask for information from various state agencies, and the reason for that is simply because the Public Service Commission deals with promotion and appointment, but it's not the employer. So your personnel file at the ministry will be completely different to the one at the Public Service Commission. So I don't want the court to have the impression that there was a duplication in the requests at all. That's not the case. And oftentimes they produce information that the other should have that they didn't disclose. That's why we have to approach it in such a piecemeal and painstaking manner to be very careful. Now, my lady, at page 194, sorry. Oh yeah, it's the small separate bundle. Well, the information that was provided, remember we got access to his personal file and we got access to the job spec. Basically, what we had sufficient based on what was provided and the orders made by the court, so we were happy to proceed. My lords, my lady,
Thank you.
with respect to the appeal as of right versus grounds of public importance, my lord, if I take you to the order that was made granting leave at page, what page? It's at page 148. If I take you to page 146, you will see the grounds at page 145 from letter C. From B, you will see from C, we pleaded the grounds for the public importance point. So it was as of right and as a matter of public importance. And the order, normally if the order was to exclude one or the other, the order would say. And at page 148, the order granting leave does not say it is pursuant to the Judicial Review Act, but not Section 1092A of the Constitution. So that's why I took it that the order embraced both grounds, because if they had to exclude one, they would do so in the order. Now, my lord, with respect to the evaluative finding on the evidence, there is no evidential basis to support the finding of the Court of Appeal upon which its ultimate decision rests. And we say that the order is bad and the appeal should be allowed because there is no justification for the breach of the pre-action protocol. And the justification that is given in the judgment that it was not a case where the pre-action protocol was ignored, we say that cannot be substantiated. It was in fact ignored. there were attempts to comply. Well, that was not a genuine attempt to comply at all, and that this idea that the scope and breadth was voluminous, we say that that is a matter for positive evidence, because had they raised that as an issue, we would have been able to properly reply to it. But that's simply, it's not fair as a matter of procedural justice for the court to base its decision on a reason that wasn't raised by the respondent itself in its correspondence to us. It's simply not fair, and it's not in the evidence. Anything else? My Lords, I think. My Lords, we have, in the speaking note, we have set out some of the relevant passages from the English cases. Yeah. Suffice it to say in concluding that in England, the issue of costs have also engaged the Court of Appeal, and they have made very strong pronouncements on the importance of compliance with the pre-action protocol. Indeed. And we say that we ask that those principles be followed in this appeal and the appeal below. Thank you, my Lord. I'm obliged.
We're very grateful to both counsel and those sitting behind them for all the assistance they've been able to give us. We'll now take time to consider what's been said and consider our judgment.